As I've led the surety practice here for the Mahoney Group, I've actually had the opportunity to, unfortunately, be a consumer of my own product. My father passed away pretty unexpectedly earlier in the year, and I was to be the administrator of his estate. And every state has its own probate laws, but in our case, we needed to provide a copy of his will that stated that I would not have to post a bond as the administrator. We could not find an original copy of the will right away when he passed away, and so I had to call my friendly probate bond underwriter with whom we do business and ask that they would co-sign my obligation to my family to honor my father's intentions, deal fairly and honestly with my fellow heirs, and sort out the details of the estate.
Will you still need me? Will you still feed me when I'm 64?
And now the podcast where together we discuss proactive aging on your terms, connecting to the professional advice of our special guests while creating better days throughout the aging process. Now here's your host, Mark Turnbull.
Hello, everyone, and welcome back to another lively discussion on aging today. And I just want to remind everybody that we are the podcast where together we explore the many options to aging on your terms. You can find Aging Today, and yes, we've been on the air for 8 years and over 500 episodes, and just about any topic on the aging related areas we've addressed, and we're addressing more and more as we move forward into the future. So tune in, go to our website. It's www.agingtoday.us. It's agingtoday.us. And then I just want to say thank you for all of the many followers that have been tuning in for the past 8 years. I love you. You've done a great job of, sending out the message that aging today, and we want to address all of the questions that people have on aging. And there are a myriad of them. It's not easy aging, and we always say that if you're not too busy being born, you're too busy aging. So it applies to all of us. It does not matter your age. So tune in, and I just want to say thank you. Thank you from the bottom of my heart for supporting us over the past 8 years. Well, there's nothing easy about being a leader and a manager, and there's so many things that go into being a great leader. And one of those things that about being a leader is that you have to wear many hats. And one of a couple of things that are the qualities of a great leader is that you're all about managing risk. And when it comes to managing risk, you're acting lawfully. You're not only that, you're a peacemaker, you're a manager, and you have to be ethical when it comes to being, and if you're ever asked, to be an executor. And that's what it takes to be an executor. You got to manage those risks that are out there. And here to guide us down that road of managing risk is our guest, Matt Snowden. You may know Matt from behind the scenes over the past 8 years. He's been with Aging Today. And I just want to say, Matt, thank you for all the efforts that you've done in making this show possible in the past. But now in the future, looking forward, we get to see your face, and we're going to talk about your expertise. And what we're going to be talking about is conservatorship and probate bonds. Matt, welcome to Aging Today.
Thanks, Mark. Honored to be here with you.
Yeah. It's good to see your face out there in the public, and I'm so looking forward to our conversation today. So, Matt,
likewise,
we always start out our episodes, as you know, with what's in your story, and we want to know a little bit about you. So tell us how you got to be an expert in the insurance industry, and in particular when it comes to probate, when it comes to bonds, and then how you can help manage our risk moving forward.
Sure. Thanks, Mark. I'd love to. I grew up in a small town in Appalachia and made my way to Arizona State, where I studied finance, spent my career in financial services, and left one of the largest banks in the world to get into the insurance business, which is an unusual statement for someone to say. And Within the insurance business, there's this really unique niche called bonding or surety. And so it's underwritten and issued by insurance companies, but it's actually not an insurance policy. It's a financial guarantee. It's to co-sign a promise that somebody made or a surety bond. And so given my financial background, when I got into the insurance business, this niche within a niche of helping folks navigate when a promise was made, could an insurance company stand beside them or behind them and guarantee that promise was fulfilled, became a very interesting place for me to spend my time. Flash forward, I built a company and sold it to one of the largest firms in the country. And then as I've led the surety practice here for the Mahoney Group, I've actually had the opportunity to, unfortunately, be a consumer of my own product. My father passed away pretty unexpectedly earlier in the year, and I was to be the administrator of his estate. And every state has its own probate laws, but in our case, we needed to provide a copy of his will that stated that I would not have to post a bond as the administrator. We could not find an original copy of the will right away when he passed away, and so I had to call my friendly probate bond underwriter with whom we do business and ask that they would co-sign my obligation to my family to honor my father's intentions, deal fairly and honestly with my fellow heirs, and sort out the details of the estate. We got through that, or I should say, we're still in the middle of that, but we found the original will, and so we were able to release that bond after the process had begun. But had we not found it, I'd still be co-signed, so to speak, by the surety company that felt that I was credible and credit-worthy enough to stand in that fiduciary position on behalf of my father's estate.
Yeah. And like I said in my intro, is that being a leader, being an executor administrator of an estate, when you've ever been asked to do that, it is a daunting task. And there's so many things that you're introduced to that are new. And one of those things that oftentimes, at least it is for me, because I'm also the executor to my mom and dad's estate. And as I'm walking through that myself, I'm being introduced to all these terms that I've heard, but I really never really understood. And when you start practicing being the executor and then you see the implications to these terms, it takes on a whole new meaning.
It really does. And we should probably clarify for everybody, we're not attorneys. This is not legal advice. And you should certainly consult an attorney because we're going to talk about that later. But you do live in a world that for most of us is one or two times in a lifetime that you have to navigate the probate process and the duties that are placed upon you. And having dealt with finances my entire professional life and knowing generally what was going on with my father's estate, but not all of the details. I even found myself at times operating out of order. And so I had to go get legal counsel of my own to understand in this particular case, what's the appropriate, customary, and necessary course of action so that A, I'm honoring the intention of the estate, and B, I'm not putting my own personal financial well-being at risk, because you find yourself at times, if you operate outside of what is prescribed in that state under that state's legal hierarchy for estate matters or trustee matters, fiduciary matters, you could find yourself being personally financially liable for those decisions that you execute on behalf of the estate. And certainly my children like Christmas presents, and my wife likes to live indoors, and so we wouldn't want to find me unintentionally making mistakes that cost us any of those important things that we've worked hard for.
Yeah, absolutely. So let's begin with some definitions of some terms that we're going to be throwing out in our conversation today, because I really want people to understand the power and the impact of understanding what these terms mean, so that when you're having a conversation, it's an intelligent conversation and you don't get mixed up and crossed over, because that's when you get into trouble. All right. So let's start with an executor. So, well, actually, let's go back even further. A will. So,
okay.
I think it's pretty self-explanatory what a will is, but I think it's important to not only understand what a will is and what's in the will, but what happens, and I know I don't want to go into great detail, but if you don't know that you have a will, then what?
It's a great question. So as a living person, we will all eventually pass away, and that will is the document that's intended to guide what happens to the things that matter to us once we're gone and how we'd like them to be handled by those to whom we've entrusted them. So whether it's children or animals or financial assets or real estate, it will prescribe who gets what and who's in charge of calling those shots and wrapping up those affairs. And as a living person, that's the time that you can draft that will. It can't be drafted once you're gone. You have to have drafted it. It has to meet the state requirements, which do vary by state, which is another great reason to have an attorney involved, not us. And for that to be binding, it should say who's going to be in charge. Do they need to post a bond or a surety bond, more specifically, to administer your estate and ensure their fidelity or faithful execution of their duties? And then what do they do with your stuff? And if you have liabilities, which you very likely will, even if they're small, how do those get handled? And so that will is your governing document for what is to happen with your affairs post-mortem.
Yeah, it's the instruction manual. It's the what is it was my intent for how things were to be distributed. So as the executor, your job is to follow the instructions. That's right. It's not about what I want. It's not about what I like. Yeah. It's about what my father wished, which fortunately he and I had a great relationship and I had a very good understanding of what he would wish. But in some cases, and you asked it, what happens if there's no will? Well, there's no instruction. And then the government gets to make decisions for us. And so explain what happens then. So, and I'm assuming that there's a lot of people out there that don't have a will, or they don't know that whether they have a will or not from when somebody passes. And you'll find out soon, right?
Correct. So oftentimes when there's not a will, and let me go back one step, an original will. So again, it may vary by state. The state in which my father resided, it had to be the original will. I had a copy. I did not have the original with his wet ink signature on it, and that made a big difference. And so an original copy of the will is presented to the authority, could likely be someone within the judicial system locally, and that person will look at the will, and if it exists, they will appoint the person that's supposed to be the executor. Now, if it's contested, that's a different matter entirely. If it's uncontested, hopefully it's as simple as what the will instructs. But without a will, which is very common, or in my case, as it was without an original will, you could be forced as the administrator to be qualified as the administrator, which is subject to the interpretation of the local authority, and then be appointed and have to post a bond, or the person could die intestate, which means that their affairs are really going to be governed by the judicial system and not by their wishes, because in the absence of a will, you are left to the judicial system to determine how your affairs are to be resolved post-mortem.
And is that where the term probate comes into play?
Great question. Many times the word probate gets used broadly as all things post-mortem. And so a probate bond is the bond that is guaranteeing the faithful execution of the executor, whoever that may be, whether it's a relative or perhaps an attorney or perhaps some officer of the court. But also the probate process as a verb, the probate process itself is where the judicial system dictates the terms of the resolution of that person's affairs post-mortem.
Yeah. And so you used another term that, people may not be familiar with, and that is bond. What is a bond?
In the simplest terms, the bond is a a co-guarantee of an obligation. So we have an obligation in this case to a probate process, either under a will or under probate statute, and that bond comes along and bonds itself or guarantees that the responsible party will faithfully, fiduciary, we hear that word a lot, will have faithful execution of their duties, and they'll deal fairly and honestly with everybody involved. And so the bond, underwritten by an insurance company, sold by an insurance agent, but not an insurance product, is really a guarantee that if for some reason you failed to act, the bond company would have to make it right, and then they would pursue you individually, personally, for remedy. So, for example, if you made a mistake that cost the estate or an heir $100,000, the bond company, if it had to pay that out, would not just eat that $100,000 like an insurance policy would in an auto accident. They would actually come to you personally as a guarantor of that bond and say, hey, we had to pay this out on your behalf. We now expect repayment because it is an indemnification, not an insurance product.
So 2 more terms I want to get clarified: guardian
Please.
and conservator.
Thank you. They're almost the same. So for the purposes of this conversation, the guardian or the conservator is the person who has the responsibility to act faithfully and in the best interest of a ward. We just love definitions around here. So a ward is the person, adult or minor, who the court has decided cannot handle their own financial affairs. A minor cannot enter into contracts. So by definition, a minor has to have a conservator. However, an adult with dementia, or an adult who has a brain injury, or an adult who has some sort of cognitive impairment may not be able to handle their affairs appropriately and legally. And so another qualified person steps in and administers their affairs on their behalf. And they have a duty to handle those affairs not in the best interest of the conservator, but in the best interest of the ward or the person who is found to be unable to handle their own affairs.
And there's many instances, many implications to what you just described there. And I was thinking of, maybe some adult children don't live in the same state. Maybe they're living in a different country, or maybe they're living across the United States, 3,000 miles away, and they haven't seen their parent for a very long time. They get notice, that mom, dad have dementia or, whatever.
Yes.
And then they learn about this, and how then does somebody like that get to be the conservator or the guardian of that person?
In all of these cases, I keep coming back to the importance of the attorney, not because it's my job to keep attorneys employed, but these are really complicated legal matters that vary by state and by other documents that might exist to govern someone's affairs. What happens is the attorney, and really in my business, it's pretty uncommon to allow someone to enter into a conservatorship or a probate matter without the representation of an attorney. And having been through it firsthand, I can tell you that that's not just because we like to pay attorneys. It's because these are really complicated matters that you don't deal with on a daily basis. And so what happens is that person has some impairment. Because of that impairment, they've been deemed by the judicial system, not by you and I, not by the bond company, not by their children, but by the judicial system as needing to be cared for and have their affairs handled by a third party. That third party gets appointed through a legal process and needs to be represented by an attorney. This is not a good DIY path. And then that attorney would provide the court order and their information to the bond agent, for example, myself. And we would then understand what is required by the court, how much of a bond is required, perhaps how long might this person live. We very likely need medical records to understand how long they might be with us, because these are non-cancelable obligations. Once we're in a relationship like this, we cannot get out of it until the court deems it no longer necessary. And so that legal process tells us what commitment is required. We then have to qualify that caretaker as being worthy of a bond guarantee. Not everyone can qualify. Personal credit, personal assets, all of those things come into play in deciding whether or not that person can actually obtain the required bond. And sometimes siblings have to make tough calls about who's the person that's the most likely to be able to satisfy the court, be able to satisfy the bond company, and then take care of this person that they care about.
As a surety practice leader, that's your title?
Yes. Yes.
Okay. So as a surety practice leader, when somebody gets into this situation where they need a bond,
yes,
who contacts you? Is it my responsibility as when I learned that I'm now the executor, or is it the court's responsibility? Who puts the parties together?
Yeah, let's assume for a moment that the executor or the administrator in either case is a loved one. They're not a professional that's in the business of doing this as a service. They're not mandated by the state to do this, that this is someone who has stepped into this role as the responsible party for someone else. Many times they will be told by their attorney, you need to go get a bond. They might as well have told them to fly to Mars because they've never done it before and they have no idea what that means.
Yeah.
And no, it is not a bail bond that gets you out of jail. This is a completely different solution provided through insurance agencies, and not all insurance agencies do this. So either the newly appointed administrator has a requirement by the court to obtain a bond, or they know one is coming and they want to make sure that they can get it before the court orders it. Their attorney may very likely know who to call. So many times the attorney will say, here, you should contact Matt at the Mahoney Group. Here's his contact information, or the attorney may initiate contact. But my client is ultimately the administrator or the executor or the person that has been appointed as custodian, depending on the details. My client is not the attorney. It is not the infirmed person, and it is not the deceased, nor is it the state. It's the individual that has to post the guarantee that we have to co-sign.
Which is the executor.
Executor, that's right.
Would be the or administrator, because those two
executor
two
or the
terms
administrator, depending on the state. That is typically a state-dependent criteria, and we work across all 50 states. And so I would hesitate to even begin to tell you what each state's specific requirement is. And the same is true if it's a living ward. So if it's an adult or a child, either case, a minor or an adult that can no longer care for themselves, it's the person appointed to handle their financial affairs.
So is it fair to say that there's two types of bonds? And a bond is basically an insurance marker, correct? Is that a good way to also describe what a bond is? It's an insurance
bond is not
marker,
insurance
a protection.
because it's not insurance because with insurance, there's an expectation of loss. So there's an expectation that in the event of a claim, the insurance company will pay the bill and you're not going to pay them back as the client, as the insured. In our business, if the bond company has to step in and make a payment, even though it says insurance company at the top, it is not an insurance product. It's a guarantee, and you're expected to repay that loss. So no, it is not an insurance product. It's a guarantee. It's more like credit, even though it's not. There is no credit, no loan going on. It is more like credit than it is insurance.
So you're just saying that the person that's the executor is capable of being protected?
We found them to be trustworthy.
Trustworthy. Okay, that's
and if they're not, and you have to come to the estate or the ward, because this all falls under the term of probate, whether it's a living ward or a deceased person. In both cases, it falls under the probate umbrella. Our client, we are guaranteeing their faithful execution of duties, and if they don't, our client actually owes us back the money, and it's the estate or the ward that is being protected by this product. So the administrator or the executor, again, depending on the state, we're not protecting them. We're simply providing a co-guarantee of
Great
their faithful
clarification.
execution.
Great clarification. I thought it was where you were you're guaranteeing that their validity, but if something were to go sideways, the executor still is financially responsible. They're on the hook.
That's exactly right.
Gotcha.
It's a
See,
very
that's where it got
nuanced world.
Yeah, it got kind of confusing for me because the Mahoney Group is an insurance, and I was thinking that it was acting a lot like insurance does, where you're protecting me as the executor. All you're doing is making sure to let the court system know that I'm valid as the executor.
You're essentially paying me to not take your side in the event of a disagreement, as funny as that sounds.
Yeah, that is so bizarre. Okay.
Yeah.
And this is the complexity of our legal system. This is the complexity of, estate planning. Why it, I get it. Why you say, hey, we're not promoting, lawyers so much, but we are promoting the protection, and a lawyer can give you that kind of protection.
That's right. We need their guidance. Because you're only going to do this, hopefully zero, maybe once or twice in your life. And so the last thing you want is to DIY one of the most complicated responsibilities you'll ever take on, usually in a time of grief. And usually people want to act with good intention. Good intention is not always what the law is looking for. Sometimes there's an expectation that's a little different than what you think the good intention might be.
Well, I'm glad we got that clarified. Because I'm also the executor to my mom and dad's estate. And my dad has since passed away. My mom is still living. But after my dad passed, it's amazing how much time I've spent in front of the attorneys, even though they had a will and it was very well spelled out. It was I's were dotted, the T's were crossed. But everything changes. And I would never have known that the trust would have changed, and then there's kind of new things I've been learning is that they had a trust between the two of them. And then when one passes, then there's a survivor's trust, there's a marital trust, and then there's an exemption trust. And it keeps going on and on and on. And it's like, there's no way I would have been blindsided.
It's very complicated. And And there's a reason, we're not trying to be difficult, but when someone calls, and it's not unique to our firm, and they say we need a bond for a probate matter or living wards, minors and adults that require a custodian, it's a very stressful time, and we don't like to say it, but it's very difficult to place a bond with a bond company in the absence of legal representation, because it is so easy, to your point, to unintentionally find yourself on the wrong side of a document or a rule or an understanding. And we really do rely on the attorneys to navigate the process. And we're just there to ensure faithful execution.
Did you know that the unexpected death or incapacitation of a loved one can require someone to step in and handle their affairs, with a financial and legal burden to act in their best interest, with a personally guaranteed surety bond? Advanced planning and knowing in advance who to call and how to navigate the obligation will allow you to focus on your loved ones without the delays, burdens, and distractions of challenging questions and decisions from a bond underwriter. This Did You Know segment is provided by Matthew Snowden with the Mahoney Group and brought to you by Royal Hospice of Oregon.
Yeah. Now, how long have you been practicing being a surety?
I started in the business. I left banking in 2014 and have progressed through the surety business for, I guess that puts us just over 10 years.
And you must have a million stories.
I do. Rarely are they happy stories, because they're usually really difficult situations that we confront.
Yeah.
And remember, I do a wide variety of bonds. So I don't only do probate bonds, but they're usually the ones that stand out as the greatest stories from tugging at your heartstrings, wanting to helping folks navigate challenging situations. We we got a call one time from a gentleman who he had lost his adult daughter and had taken custody of his minor granddaughter. And the situation around his adult daughter's passing was heartbreaking. And here's this poor granddaughter that needs somebody to care for her. And he's the best solution according to the courts and according to his heart. And we had to find a way. And again, he was represented by an attorney, which was critically important. We had to find a way to find a bond company that would honor an obligation that might last another, I think, 16 years, because she was a very, very small child. And so we're trying to, in a time of grief, with great complication, find a bond company that will step in and say, we will co-sign this commitment for faithful execution until this child reaches the age of majority, which is typically 18, as long as they're fully functional and can become a legal adult. And with that, we were scrambling to make sure that he could fulfill his familial commitments. And we've had cases where adult children were taking care of aged parents, and we had to ask really difficult questions about medical records, because as interesting as it is to think about it this way, the longer that aging parent might live, the more difficult it is to find somebody that will enter into a non-cancelable commitment that you will be faithful to your duties for as long as that person lives. We cannot cancel that commitment once it's made in most states. So with a child, you at least have an idea of when they're going to reach age of majority. With an adult who is requiring a custodian, that could go on for decades if they're in relatively good health and just not able to handle their affairs.
Yeah. So just to be clear, a probate bond doesn't always go into effect. Not the only time, but the time that it does is when there's no will. That's a gimme.
It's one of the most common triggers. So in the absence of a will, at least in the states where I'm specifically thinking about, in the absence of a will that states that the administrator doesn't have to post a bond, because that's another statement. In the absence of that statement, you could find yourself posting a bond even under a will. So it's in an original will at that. And so a bond is not always required in the event of someone's death, but when someone steps into that executor or administrator role, if the advanced planning was not sufficient and the right documents are not readily available, you could find yourself in the position of needing to urgently post a financial commitment, a bond, to step in and handle their affairs without all the right guidelines that you or guidance that you would need to make sure that you're doing things to their wishes and to your heir. I mean, you have fellow heirs in many cases, and so you're mourning the loss of a loved one, and you're also navigating your fellow heirs' interest, and you can't put yours above theirs. Your interest above theirs is a violation of trust.
Yeah. So there's a probate bond, and what are some of the other types of bonds? There's a conservator bond.
Yeah, for our aging population, we're really going to say that within the world of probate bonds, it breaks down into living and deceased. In the deceased category, it is someone who has passed away. A person has been appointed as responsible for administering their affairs post-mortem. That person may be required to post a bond depending on the state, depending on the size of the estate, and depending on the documentation around their death. That's probate in the traditional post-mortem sense. On the other side of the probate bond world are living wards. And a ward is a person that cannot take care of themselves, either because they haven't reached the age of majority, meaning they're a minor, or they're a living adult. And in both of those cases, that administrator that is stepping into that role could be a guardian, could be a conservator. It goes by different names in different states, but it's that person that's responsible for faithfully handling their financial affairs and making decisions for them that are in the best interest of the ward, not in the best interest of the person taking care of their affairs.
When somebody that doesn't have family and they become mentally incapacitated where
Yes.
they can no longer make decisions for themselves. Who appoints a conservator or a guardian? Is that where
Typically, it would be the state will have a judicial process, and through that judicial process, they will appoint a representative. A personal representative is another term that you commonly hear in our business. And so they will appoint someone to the role of conservator, administrator, whatever the state requires.
Do they have a preference? Because there are professional conservators, guardians out there that do this for a living.
Sure.
But then they could maybe say, well, based on Jack's, he had a close neighbor. Would they jump in and do that, or maybe some distant relative that is living in Ethiopia someplace?
Yeah, good question. If that interested party is presented to the court and the court deems them to be appropriate, then they can be appointed. Grandparents are a good example. It's not the parents of the ward, it's the grandparents, and the grandparents are obviously intending to take care of this person. It's not always automatic, again, in the absence of proper planning. And that's really the whole message that I have for your audience today, Mark. I don't ever want you to need my services. Consult with a proper estate planning attorney that's qualified to do the documentation appropriate for your state. If you move, if your family composition changes, if your assets materially change, if you have children, whatever the case may be, update that document as time goes on so that it is current to where you are in your life. For example, my wife and I did our estate planning. We started it before we had children. We contemplated future heirs in our estate plan before we had children, so that if something were to happen to us before we updated the documents, they were ready for our children to step into that first in line position. So yes, an interested party can be appointed, and that's really going to come down to that particular state and how their judicial process recognizes other interested parties and their standing.
You kind of alluded to this in a while back, but how long does a probate bond last?
Great question.
It's because it can go on for a long time, or it could be a short time. What's long
it's
and what's
typically
short?
a non-cancelable obligation that will renew annually until the estate is closed. Many simple estates can be closed inside of a year. And all we look for is documentation from the local jurisdiction that shows that you've satisfactorily closed the estate and that we can release our bond. And everybody in the transaction will be familiar with that, and you'll get the required documentation. I'm also familiar with what I would call not super complex estates that have drug on for 8 years. And the reason they've drug on is the estate administrators have open items. Maybe there was complexity to a particular holding or a fellow dispute with an heir that just hadn't been resolved. This can go on for many years, and you're going to pay that bond premium each year that you need to renew the commitment. And your bond premium is based on the size of the assets, and it's stipulated by the local judicial system. So we actually can't issue a bond without a judicial order that tells us the size and the party, and then we can issue, then if with attorney representation and satisfactory credit and assets, then we can enter into that commitment that again is non-cancelable. So we're with you from a guarantee standpoint until you resolve the estate.
Yeah. Do you have any stories to tell about how there were triggers that have happened with executors where they got into trouble? And maybe there's some things that you can share with us to help all of those of us that are as executors, things that we need to be aware of so that we don't get blindsided down the road.
Yeah, I can give you a really, it's relatively small and simple, but it also illustrates the magnitude of what could be an otherwise small and routine decision. So familiar with an estate where, again, not particularly large, no real dispute among the heirs. There was a little bit of complexity in the financial affairs. When the individual passed away, the administrator stepped in and began sorting out the bank accounts, the credit card statements, any bank loans. Okay, we have these assets, we have these liabilities. Well, at that moment in time, it appeared as though there were going to be sufficient cash assets to satisfy the credit cards and to start resolving the matters so that they could just quickly transition the estate and close it. Well, pretty quickly, it became apparent that there were open liabilities that were not obvious right away. Money was paid out of in this case, a business checking account to satisfy a loan. And then new liabilities came to light that would have had priority over that loan that was paid off, because there's an order of priority in an estate, and it's driven by statute, and it's different by each state. And so you, as a normal person operating in totally goodwill, might think, well, this is a simple bill. I'm just going to pay this one and get it taken care of. If you pay some bill out of order, and this was the trigger in this case, that there were priority claims that had not been satisfied. There were legal bills that needed to be paid to keep proper representation of the estate intact. And there were tax matters that had to be resolved. Funds were used to pay a non-priority creditor before they should have been paid, and additional liquidity came into the estate and everything worked out okay. But that administrator could have potentially found themselves in a position where they were personally responsible for making right a financial transaction that could not be unwound because they were just operating in good faith, and good faith is not enough. There's also statute, and that's why the attorney guidance is so important to helping you pay the right people at the right time and not finding yourself on the wrong side of a claim, bonded or unbonded. It's true either way. Even in the absence of a bond, because all the proper planning was in place, you could still find yourself on the wrong side of priority if you don't get good legal guidance.
Yeah. So the obvious question is, how much does it cost? And
oh yeah, good question.
Who pays it? You always got to ask the question.
It's a great question. So it's going to vary by creditworthiness of the applicant. It's going to vary by state, and it's going to vary by size. A routine, call it $200,000, relatively small estate that's not complex. You're probably talking $400 for the year, maybe $500 for the year for the bond. As the bond amount gets larger and the commitment gets longer, those can go up pretty substantially. But a relatively small estate that's only likely to be open for a year, not terribly expensive. A living ward,
but it's on a sliding scale.
It is. So the larger the estate, the larger the bond requirement that's going to be imposed on you by the court, and the larger the bond requirement, the larger the premium, because our bond premium is just a percentage typically of the bond amount. And it is more expensive, so to speak, to guarantee the affairs of a living ward than it is to guarantee the faithful administration of a deceased's estate.
What happens when you run out of money?
I have a problem in my world.
Because, a lot of times, people are cash poor and property rich or asset rich, whatever that means. Then what happens?
Well, you actually asked two different questions, which are both very interesting. The first one is, what happens if we have assets but not enough cash to pay the bills? In that case, you're either faced with injecting outside cash to satisfy the affairs of the estate, which you're typically not required to do. So you're, in a lot of ways, throwing good money after bad, or you're forced to start liquidating assets of the estate to create liquidity and pay bills. And many times you can work with all of the interested parties and establish, hey, we're going to sell these assets, we're going to pay these bills. It's all very administratively driven by the judicial system, and so they will typically expect an accounting of the estate, and you'll have to answer for, we had this much in assets, they were this kind of property, this kind of cash, this kind of chattel, or cars, boats, guns, whatever the person owned. This is how we liquidated them. We turned them into this much cash, and we paid these bills. And there's a claims process where a creditor is notified, needs to be notified of the death of an individual, and then they need to file a claim with the appropriate authority, and then that authority has a record that you are responsible to pay that debt out of the proceeds of the estate before you can close it. And in the event that the estate does not have sufficient assets, even after liquidation, to pay all of the creditors, again, you need to consult with an attorney, but you're effectively dealing with a bankrupt estate, and so whatever's available will go to the priority creditors with nothing left for those that don't have priority. And in many cases, that can be the heirs of the deceased that don't get anything.
Yeah. And I'm wondering if, I don't know if you see this or if this is more of an attorney type question, but let's say I find out in the will that I'm the executor, and because of all this conversation, I don't want to be the executor. I don't want to be on the hook. Can I back out of being the executor?
Yeah, you're going to want to get legal representation.
That's right.
It's typically, you typically can't be conscribed to service. In most cases, you have to accept the responsibility, and if you don't, then there's typically a judicial process to appoint the next in line. Yeah, in some cases, there can be disputes among the heirs, and so sometimes the court has to hear that dispute to also adjudicate who's going to be in charge.
Yeah. Is there anything else that you want to share with us about probate bonds? And
I think it's
how
important.
They work.
Yeah, I think it's just important to understand that the bond company is not there to protect you. The bond company is there as a backstop.
My biggest takeaway.
Yeah. I wish I could tell you that, we're your best friend when we write the bond and we're your worst enemy when things go wrong. And it's not because we desire that. It's just the nature of the obligation. And we're not legal counsel. You really do need qualified legal counsel, typically in that local market where you're dealing with the issue. In your example, where an heir is across the country, there's a very good chance that they're going to need to hire local counsel to navigate the complexities of that local matter. And the best thing I can say is don't need me. Do proper estate planning for your loved ones. As difficult as it is, consult with your loved ones that may pass ahead of you and get them engaged in the planning process. Even if they don't want to tell you what's in the document, at least have the document and know where it is and how to access it in the time of need. Mark, I'm sure on your program you've talked about advanced directives. Many times that gets bundled in with this, and it can really, nobody comes to us having the best day of their life and needing a probate bond because they've either had to step in and take care of a ward or because they've lost a loved one. We just add stress to the process, and that's not what we want. It's just the nature of bonds are a very invasive underwriting process. It's like qualifying for a mortgage. We have to know a lot about you. And many times that document may not even be handy because you're across the country contending with immediate challenges that need to be dealt with. And so the more advanced preparation, the better. There are cases where folks, sometimes say a terrible auto accident that puts a minor in a position of needing a conservator. We can't always plan our way out of that, but really good legal counsel can help you navigate those obligations so that when you do come to us, you're prepared for what it is exactly that the court is going to mandate that you provide.
Yeah. So I got one final question for you, and just maybe a statement. Here I thought that you were going to protect me like the good friend that you have always been. You've always been protecting me over the last 8 years. But now I don't need you, Matt, because I've got everything's taken care of in the will as the executor. Hopefully, knock on wood, I'm not going to need a probate bond moving forward. But that doesn't mean that I still can't be your friend.
I've never been more happy not to earn your business, Mark.
So tell us a little bit about those that are listening out there, and they maybe are in a place where the will isn't clear and they need a probate bond. Tell us a little bit about you and how they can get in touch with you and how all that works.
Sure. We're in the business of being found when you need us. And so It could be as simple as writing it down and putting it in the file of important papers that, open upon death or when needed or whatever the case. But I'm pretty simple to find. My name is Matt Snowden, Snowden. My email is msnowden, msnowden at mahoneygroup.com. That's msnowden at mahoneygroup.com. My phone number is 623-215-1378. Again, 623-215-1378. I don't get texts at that number. You actually have to use it as a telephone, which I know is a crazy concept in today's world, but typically, if I don't pick up, I get back to you within 24 hours. And, these things are challenging. And so if you have advanced questions, I'm more than happy to answer them in hopes that you never need what I have to offer.
Yeah. Well, and I just want to validate Matt, and I've known him for the past 8 years, and he's a man of integrity. And if you do need that assistance, or if you do need to ask more in-depth questions or scenarios, Matt will be able to assist you and help you to resolve the conflict that you might find yourself in.
Honored
Matt,
by that compliment, Mark. Thank you.
Yeah. And Matt, I just want to say thank you for your friendship. Thank you for supporting Aging Today. And I just also want to say thank you for, everything that you've done for us, and the service that you can bring to our listening audience, I think, is incredible. And you can serve all 50 states, correct?
We can, yeah.
Yeah. Perfect.
Thanks.
All right. Well, thanks again for being on Aging Today. And this is Mark Turnbull, your host, and I want to thank all of you for tuning in to Aging Today. We are the podcast where together we're exploring the many options to aging on your terms. And remember this, we're all aging, and we're all in the process of aging. And as we age, we really are better together. So stay young at heart.
You make me feel so young. You make me feel like spring has sprung. And every time I see your face, I'm such a happy individual. The moment that you speak, I want to go play hide and seek. I want to go and bounce the moon just like a toy balloon. Well, you and I are just like a couple of tots running across the meadow, picking up lots of forget-me-nots. So you made me feel so young. You made me feel there are songs to be sung, bells to be rung, and a wonderful fling to be flung. And even when I'm old and gray.
You've been listening to Aging Today, where together we explore the options to aging on your terms. Join Mark and his guest next week for another lively discussion on proactively aging on your terms, connecting you to the professional advice of his special guests, with the goal of creating better days throughout the aging process. Your host has been Mark Turnbull. Join Mark and his guests every week on Aging Today, your podcast to exploring your options for aging on your terms.
And even when I'm old and gray, you make me feel the way I feel today. 'Cause you make me feel so. You make me feel so. You make me feel so young. So young. You make me feel so young. You make me feel so young.